The reason to put as much as you can, perhaps, or as much as is feasible into a written contract, really for the employer, it's certainty. The employment law in Canada has developed a pretty healthy set of case law in relation to all kinds of different principles. And you can have an employment contract that is fairly perfunctory in its terms, but what that leaves is the balance of the relationship to basically be sorted out by the case law. If you want increased certainty in relation to what the relationship between you and your employee is, you have an opportunity to put it into a written contract of employment. You have an opportunity in an employment contract to specify what happens on termination, right? And if done properly, it can be binding, and it takes you out of the relative uncertainty of the common law.
So as Matt sort of touched on, if you don't have an employment contract in place that sets out exactly what the terms and expectations are of both of the parties, employer and employee, you're going to default back to the minimums that are set out in the Employment Standards Code, of course, here in Alberta, or the other employment standards legislation you may have across the country, depending on where you are, and then to the common law. And again, the real focus here is just the employers and employees don't really have any risk mitigation in place without having that clearly defined employment contract. And so if you do have a dispute about, okay, you need to now terminate this employee, well, how much notice do you need to give them? You know, are you going to, are they still going to be entitled to bonuses that they've typically gotten? How are you going to deal with sort of the conclusion of their benefits? These are all questions that are now open question marks that you'll have to address, and you won't have any sort of place to turn back to then know how to move forward in that dispute or in that end of the relationship.
The enforceability sort of depends on, clear terms around the employment relationship. And so, for the most part, that may be self-evident, but when you get into certain clauses like termination clauses, and restrictive covenants, so non-competition clauses, non-solicitation clauses, where courts will scrutinize them very closely and ensure that they meet the framework that's set out in the jurisprudence. So that's new employees. It is relatively simple, I would say, because of that aspect of consideration is there. And so really, if things are well organized and the agreement is signed in advance, typically that sets the employer up for in a good position to be able to enforce the employment agreement. Existing employees, it's a little trickier because they're already employed and have existing terms and conditions of employment. And so that aspect of the offer acceptance consideration is already in play. There's already a binding agreement based on the other terms, be it implied or written, as Matt alluded to. A lot of it, I think, can be addressed with some level of transparency and candidness with employees and being open about the employment contract. The employment contract can speak for itself, but in terms of why they're being introduced, be it updating terms, clarifying terms and conditions of employment, you can do that. And you can introduce it to the employee, but you've got to be careful in insisting that they sign it.